afternoon, and thank you for joining me for today's webinar about why superannuation is an important part of estate planning. My name is Cathy Vo, and I am a solicitor and a director at GLG Legal. I have been practicing as a lawyer for almost 17 years and providing legal advice to clients on all aspects of wills and estates. GLG Legal provide the following services: wills and estates, conveyancing, family law, and business law. We currently have offices at Brookwater, Redland Bay, and the inner city. Superannuation may not be the most exciting topic to talk about, but it plays a very crucial part in estate planning. Superannuation is fast becoming a major asset for many people. For some, it represents the more substantial part of their estate. However, what many people don't realise is that superannuation is a non-estate asset and is often not covered adequately in an estate plan, or may even be overlooked altogether when the will is prepared. Your superannuation is a non-estate asset because your member balance within the fund is not owned by you personally. It is held on your behalf by the trustee of the fund. A superannuation fund is simply a specific form of a trust. It only becomes an asset if the trustee of your superannuation fund pays your member balance to your estate. So the questions we are going to examine in today's webinar are: who can your superannuation death benefits be paid to? Who determines the recipient of the death benefit? What documents determine the payment of your superannuation death benefits, and are there any limitations to decision making? What are the tax implications of paying your superannuation death benefits to a particular person? Is your will even relevant? And can a decision relating to the payment of your death benefits be challenged? So we'll look firstly to who can your superannuation death benefits be paid to. So the Superannuation Industry Supervision Act of 1993, which I'll call the SIS Act, and its related regulations, allow for death benefits to be paid to either your dependents, your legal personal representative, or both. So these options are explained in detail in the following sections. So dependents can include your spouse, also your de facto partner. That also includes same-sex partners and another person you are in a registered relationship with, or with whom you live on a genuine domestic basis. Any child of yours of any age, including adopted or a stepchild, a financial dependent, and also any person with whom you have an independency relationship with. So two people who have an independency relationship is if they have a close relationship, they also live together, or one or each of them provide the other with financial support, or one or each of them provides the other with domestic or personal care. So the definition of interdependency would generally include same-sex partners or other types of personal relationships, such as a sibling, a close friend, or a relative who meet all of the four criteria. Two people may still satisfy the interdependency definition if they have a close personal relationship, but they don't live together. And that could be due to a disability or temporary absence, for example, overseas employment. So the death benefit can also be paid to a legal personal representative, and that is your executor. So the legal personal representative is usually the person who is your executor in your will. They could also be your administrator if you have died intestate. So that means if you die without a will, that's a person who becomes your administrator or personal representative. If your superannuation death benefits are paid to your legal personal representative, they will then be distributed in accordance with your will as your estate assets. So who determines the recipient of your death benefits? So generally, in the event of death of a member of a superannuation fund, the trustee of the fund determines to whom the death benefit is to be paid to. Sounds scary, right? You've worked so hard for your super and someone gets to decide. So how can you nominate who the death benefit is to be paid to. So what documents determine the payment of your superannuation death benefits, and are there any limitations to decision making? So there are three types of documents. One is a non-binding death benefit nomination. The other is a binding death benefit nomination. And also we have the non-lapsing death benefit nomination. So what I'll do is I'll explain the differences between the three of those. So the non-binding death benefit nomination provides the member with the opportunity to nominate which person or people that member wishes to receive their death benefit. As the wishes stated on the form are non-binding on the trustee, it merely represents one matter that the trustee should take into account when exercising its discretion. Some members make the mistake of assuming that by making a non-binding nomination of a beneficiary, they are ensuring that their death benefits will be paid by the trustee as instructed. And this actually ignores the existence of the trustee's discretion. In exercising its discretion, the trustee must consider the competing claims of any other beneficiaries and determine how the super death benefit is to be distributed. This usually involves a consideration of the financial circumstances of the beneficiaries, the potential beneficiary's level of financial dependency on the deceased. For example, a minor child would have a greater level of dependency as opposed to an adult child. Other considerations involve the taxation implication of paying the death benefit to a particular beneficiary and any other particular special needs that may be relevant. So you may well expect for those types of nominations to take some months to be processed, depending on the number of competing claims which are made. There are a lot of extra documents to complete and supporting documentation to provide, which will result in delays in finalising the claim for payment of the death benefit. So now we'll move on to binding death benefit nominations. Unlike a non-binding death benefit nomination, a binding nomination allows a member to direct the trustee of the fund to pay the death benefit to a particular dependent or to the estate. If the binding death benefit nomination is valid, this removes the trustee's discretion. So the nomination is effectively locked in and it cannot be challenged. If your super fund allows you to make a binding nomination, the requirements for a valid nomination typically include the following. The nomination must be in writing and signed and dated by the member. The nomination must be witnessed by 2 independent adult witnesses, and these witnesses do not need to be qualified witnesses, but the witnesses must not be nominated as a beneficiary to receive the benefit. So what I normally tell clients is that if you do prepare your own binding death benefit nomination, you don't need to go to a solicitor's office. You can actually just get a couple of friends, neighbours, work colleagues to sign the witness you sign the death benefit nomination for you, provided they are not beneficiaries. And with the binding death benefit nominations, the nominations must also clearly identify the dependents and or the legal personal representative who are to benefit, including the proportions in which they are to benefit. And the nominations with these binding death benefit nominations, they may require renewal every 3 years. So if the binding death benefit nomination fails to comply with any of the requirements for it to be valid or it has expired, the trustee maintains its discretion as to whom the death benefits are paid to. So we'll go to the final nomination. It's the non-lapsing binding death benefit nomination, which is quite similar to the binding death benefit nomination, only that they never expire unless they're either renewed or they're changed or they're revoked by the member. So even with non-lapsing nominations, it's still recommended to review it periodically, particularly when the circumstances change for the member. So for example, if they get divorced, become separated, or if there's a birth of a child. So those are the circumstances that you should consider updating your non-lapsing binding death benefit nominations. So Now I'll discuss the advantages and disadvantages of a binding death benefit nomination, and these are as follows. So with the advantages with having a binding death benefit nomination is it provides you as a member with certainty. The trustee must follow the nomination, which removes the unpredictability that comes with the exercise of trustees' discretion. It will also help you achieve your estate planning objectives. For example, where the potential beneficiary suffers from a disability or is a spendthrift, so they can't manage their own money, a binding death benefit nomination can be used to direct the super in a manner that does not permit ready access to it by your beneficiary. It also removes your superannuation from being challenged or going through the Australian Financial Complaints Authority, also known as AFCA, which is the complaints regime. It also enables you to direct your superannuation directly to your dependents and not to your estate. So this keeps your superannuation out of your estate and it protects it from a challenge to your will, providing clarity and peace of mind to your loved ones. So I'll give you a case study. So John is a widower and he has a 30-year-old son who has a gambling addiction. John has considerable wealth held in his own name and also a sizable superannuation balance. Now, John doesn't want for his son to be able to have full access to his assets when he dies. John has gone to see his estate planning solicitor, and the solicitor has recommended that a new will is to be drawn up for him, which incorporates a protective trust for his son. Now, John's lawyer explains to him that a protective trust means that his son will not be in control of his inheritance. Rather, it will be managed by someone other than his son, the executor. The lawyer also recommends that John signs a binding death benefit nomination, nominating his legal personal representative to receive his death benefit. It's also explained to John that his superannuation will then form part of his estate and then form part of the protective trust along with his personal assets. So that's an example where binding nominations may be relevant, but really it all depends on the personal and financial circumstances of each and every client who is a member. So now we'll move on to the disadvantages, and there are several. Disadvantages to a binding death benefit nomination, but that must be balanced up against the advantages which we've discussed previously. So a binding death benefit nomination is inflexible, as a trustee has no discretion to deal with death benefits other than in the manner specified in the nomination. This does not allow for subsequent changes in your circumstances that may have not been anticipated at the time you made the nomination, such as marriage, separation, or a birth of future children. The best possible tax outcome also at the time of your death may not be achievable if the trustee is locked in to the following nomination. The nomination may need to be reviewed every 3 years. Many funds have processes in place to remind their members of their lapsing nature, although issues still arise, however, when members fail to renew their nominations and they become invalid. There are also generally more formalities required for the preparation of a binding death benefit nomination. Issues continue to arise when members nominate people who do not meet the definition of dependent. And many super funds find that although the fund goes to considerable effort to explain the nature of binding nominations and the legislative requirements, many members still nominate people who do not meet the definition. A typical example is where a member wishes to nominate their parents to be the recipients of their death benefit. However, they are not living with their parents, nor are they providing their parents with financial support. So in this case, the trustee would not be able to make the payment to the member's parents because they do not meet the SIS Act definition of a dependent. So for many trustees, verifying the bona fides of nominated dependents at the time the nomination is made is an intrusive and unwelcome task. So now we'll move on to taxation of superannuation death benefits. So nobody enjoys paying more tax than is necessary. Even when you die, the ATO will be quick to take a cut out of your super death benefits if you aren't careful. So to avoid having your beneficiary pay more tax than is necessary, it's important to become familiar with the tax rules governing super death benefits. That way you can plan the distribution of your assets in your estate, including your super, with these rules in mind, ensuring your benefits are paid in the most tax-effective manner possible. Different taxation consequences apply to the payment of a superannuation death benefit, depending on whether the recipient is a dependent of the deceased person for tax purposes or not a death benefit dependent of the deceased for tax purposes. So the definition of a death benefit dependent is set out in the Income Tax Assessment Act 1997, and it is defined as a deceased's spouse or a former spouse, a deceased's child who is under the age of 18, any person with whom the deceased had an interdependency relationship just before he or she died. So it effectively has the same meaning as in the SIS Act, and any other person who was financially dependent on the deceased just before he or she died. In order to meet the definition of a financial dependent, a person needs to be unable to meet their normal living expenses without the financial support of the other person. So super death benefits, how are they taxed? So if you now have your head around who is and isn't a dependent under tax law, it's possible to work out how tax is applied when your beneficiaries receive their death benefit. And the tax rate applying when a super death benefit is paid to a beneficiary is different, depending on whether they were a dependent or a non-dependent, and whether the benefit is paid from a tax-free component or a taxable component of your super. Now, each component of your super death benefit paid to your beneficiary has a different tax rate. So there is tax on the tax-free component of a death benefit payment. So for this, as tax has already been paid on this money when it was contributed into your super account, the tax-free component of your super death benefit is generally paid to your beneficiaries without the need to pay any further tax. So if you're receiving defined benefit income stream, different tax rules actually apply, and you can actually access the different tax rules through the ATO website. If you want to know how to access that, just reach out to me. So if a beneficiary who is a non-tax dependent, most commonly an adult child, is likely to receive your death benefit, taking steps to increase the tax-free component of your death benefits can minimize the tax that they will pay. So tax on the taxable component of your death benefit. The beneficiaries may be required to pay tax on the taxable component of your super death benefit, and the amount of tax they pay will depend on whether your super benefit is paid to your nominated beneficiaries either as a lump sum or a superannuation income stream, whether the person receiving the benefit is a dependent under taxation law, also the age of the beneficiary or the age when you die, and whether any income stream is a cap defined benefit income stream or an account-based income stream. So the taxable component is divided into tax and untaxed elements, and most Australians are in taxed superannuation funds, which usually only contain taxed elements. So I'll go through with you a case study where the super death benefit was paid to a dependent. So Bob was a member of a large industry super fund for many years, and he nominated his wife Julie as the beneficiary of his super death benefit of $175,000. When he unexpectedly died at the age of 63, Julie applied to the super fund to receive Bob's super death benefit as a lump sum payment. As Julie was Bob's surviving spouse, she was classified as a dependent under tax law, and she received his full super death benefit of $175,000 as a tax-free lump sum. The components of the benefit doesn't matter because all components are tax-free when paid as a lump sum to a tax dependent. So what happens to tax when benefits are paid directly through the estate? So what happens in this instance is that your executor is responsible for deducting the appropriate tax when the amount is distributed to your beneficiaries. All benefits paid from the estate are taxed as lump sums. If your death benefit dependents are also the beneficiaries of your estate and are expected to benefit from the death benefit paid to your estate, then the benefit is treated as if it had been paid to your death benefit dependents and is accordingly tax-free. If the ultimate beneficiary is not a dependent according to tax law, directing the benefit via the estate has tax advantages. As the estate is not an individual, no Medicare levy is payable, so beneficiaries avoid this additional 2% cost. In addition, the benefit is not added to this assessable income, and as a result, it does not affect either other entitlements that they may be receiving based on their total assessment income, such as the family tax benefit, and it also doesn't affect any liabilities based on their assessable income, such as child support. So what relevance does your will have when you have superannuation? So despite superannuation not being an estate asset unless it is paid to an estate, wills are important when dealing with the distribution of your superannuation death benefits after death. This is particularly relevant where the intention of the will maker is to impose restrictions on the use and access to the funds via the will. So the following are circumstances where a will can be used to regulate access to superannuation death benefits. So where one of the beneficiaries is a vulnerable or spendthrift beneficiary, and you want to restrict access to income or capital, or you wish to preserve the capital for other beneficiaries in the future. Another instance is where the will incorporates the option of beneficiaries inheriting via testamentary trusts, and the payment of the superannuation death benefits to the estate will also allow the superannuation to be held in the testamentary trust. Another example is where the will maker has a disabled beneficiary, and the payment of the superannuation directly to the beneficiary would reduce or eliminate their Centrelink disability pension. So having the inclusion of an optional special disability trust provisions and the payment of the superannuation into the estate to be held in such a trust may actually preserve the entitlement to the disability pension. Or where you intend for your death benefits to be paid to people who are not your dependents under the SIS Act, and these could include grandchildren, siblings or friends. In this case, the superannuation would need to be paid into the estate and a gift would need to be made to the relevant people through the will. So can a decision relating to the payment of your death benefits be challenged? It sure can. So the Australian Financial Complaints Authority exists to resolve complaints made by beneficiaries or potential beneficiaries relating to the payment of death benefits. And although the process and the grounds for doing so, you do need to be mindful that they can be quite complex. It's important to be aware that the Australian Financial Complaints Authority actually has no jurisdiction to resolve disputes relating to self-managed super funds, including the exercise of the trustee's discretion in determining the recipients of death benefits. So in the case of self-managed funds, recourse to the court system to resolve disputes is required. So just like a will, disputes can arise in circumstances such as, where the validity of the binding death benefit nomination is in question, such as where it's not being correctly executed according to the trust deed and the SIS Act. It may be challenged on the grounds of invalidity. Validity issues can include the binding death benefit nomination needing to be updated if it's been more than 3 years old and it's not been renewed, it's been improperly witnessed, or the nominated beneficiaries are not dependents as defined by the superannuation legislation. There could also be questions regarding the capacity of the member, if it can be proved that the member was not of sound mind or undue influence. So there could be circumstances where they were influenced or pressured into signing the binding death benefit nomination when it was made. So that is a circumstances where it might be deemed invalid. Dependent status. So if a person named in the binding death benefit nomination does not meet the legal definition of a dependent under superannuation law at the time of the member's death, this could be grounds for a challenge as well. There could also be inconsistencies with estate plans, where there's a contradiction between a will and a binding death benefit nomination, can result in a legal challenge. So ensuring that your binding death benefit nomination aligns with your overall estate plan is absolutely essential. So there is a process for challenging. If a person is dissatisfied with the manner in which the trustee has determined to pay a death benefit, an objection must first be made to the trustee of the fund itself. If the complainant is still dissatisfied with the decision of the trustee following a consideration of the objection, then a complaint must be lodged with AFCA. And the AFCA will generally require the parties to attend to a conciliation conference to try and settle the dispute. If this is unsuccessful, the AFCA will proceed to review the matter, and they may either affirm the decision of the trustee, they can set aside the decision and substitute its own, they can vary the decision, or they may either remit the matter back to the trustee to reconsider the decision. So now we'll move on to self-managed super funds. So as with other superannuation funds, a self-managed superannuation fund is governed by a deed that sets out the governing rules of the fund. And one matter that affects self-managed funds is the control of the fund after death. Dealing with control is important because if you have not made a binding death benefit nomination, whoever takes control of the fund has the discretion to pay out the benefits to the beneficiary of their choice. The SIS Act enables the legal personal representative or a member to be a trustee or a director of the trustee company in the place of the deceased member. And that commences from the time of the member's death and ending when the death benefits commence to be paid. Therefore, when making a will, a critical decision is the appointment of the executors of the will. If the trustee is a company, careful consideration also needs to be given as to who the shares in the trustee company are to pass to in your will. So we'll move on to a case study. So Hugo has 2 children. He also has a self-managed super fund with a sizable member balance. Hugo is a trustee along with his eldest son, Mark. Hugo has also appointed Mark as his executor. At Hugo's death, Mark will obtain control of the fund, both in his capacity as the trustee and executor, the latter for the period of time from death until the death benefit commences to be paid. So Hugo has never made a binding death benefit nomination. Therefore, Mark exercises discretion to pay the entire benefit to himself, to the exclusion of his youngest brother. This case study highlights the importance of including an adjustment clause in the will. So making a choice in relation to whom will be nominated as beneficiaries from a member's death benefit is an exercise of personal choice. With the increasing wealth in superannuation funds, it is extremely important to consider the payment of superannuation death benefits as part of your overall estate plan. It is also essential that superannuation planning be reviewed as often as you would review and update your will to take into account changes to your circumstances and the circumstances of your beneficiaries. So I'd like to thank you all for attending today's webinar on why superannuation is an important part of estate planning. If you would like to know more or have any questions about this webinar, just email us at info@glglegal.com.au. I hope you all have a lovely day. Bye for now.